and to have a safe environment at the place of work. And for that purpose, the CEDAW, this is Convention regarding elimination of discrimination against women. You see, no specific law enacted on that, but that was relied on to be read in 14, 15, 19 and 21 to enlarge their scope. And the Beijing principles of independence of Beijing principles relating to the independence of judiciary, which were adopted finally in the Manila Conference in 1997, which require the judiciary to protect the human rights. They were all relied on. And the judgment also said, as a canon of construction, you can rely on international law to enlarge the scope of the existing constitutional guarantees. So the role of the judiciary, more because of the peculiar conditions of the country, has been enlarged to this extent. I've taken a lot of time, so I must now conclude with just a little one thing more, which I won't give you any more examples. There are too many which all of you know. Let me come to something which is troubling the mind of everyone. Two things only I'll say and then conclude. The National Human Rights Commission was constituted in 1993 under the Protection of Human Rights Act, passed that way, more to respect the Paris principles because of the political international pressure, etc., etc. Even those who enacted it did it more for the purpose of compliance, didn't expect it to be a very potent institution. But because of the complementarity developed between the Supreme Court and the NHRC, the judiciary and the NHRC have been able to do much more together. For example, monitoring of child labor, bonded labor, protection home, this, that, etc. All those things. As I said, as the Chief Justice of India, I could not have gone to Gujarat after the communal violence, but as Chairman of NHRC I could go. And if they didn't comply with, Supreme Court was always there, and the Supreme Court did take up the issues later on. So together they have been able to perform better. This is one further development. Then there are too many recent instances, I don't want to go into all of that. Lokpal bill where people have been talking. Well, I have spoken only once, and now on this occasion I think I'll repeat what I've said earlier. Because otherwise every day, day in and day out, it is so nauseating. You open any channel, there's a panel discussion where everyone is at the throat of everyone else. And everyone seems to abandon all democratic norms. And people think, what I say is the only correct thing. If you don't, you see, accept what I am saying, then either you are corrupt or you are promoting corruption. You don't want to be strong Lokpal. Well, I think in a democracy, everyone has a right to voice his opinion, give his views, and entitled to also have his views considered. But no one can say that what I say is the only thing to be done, and you must therefore do it. That's not democratic. Because there's someone else who has got to decide. In our constitutional framework, the law has ultimately to be made by the legislature. It is no use saying that you can buy voters or members of the legislature are not the right kind. After all, we have voted them into that position, they are there. If you think they are not worthy of it, well, don't vote them again. But while they are there, it's like this. You can't say, well, this judge I don't like, so I'll decide the case myself. You can't. So, I mean, that's the basic thing to remember. So I think that is one thing in a debate in a democratic society we must remember. Well, I'm upset, and I'm sure at least most of you would be at these basic democratic norms being thrown to the wind. Now, two issues particularly, which appeared to be the main bone of contention, you see. And since I've already spoken about both of them, and I'll give you the reasons also. And I'm only repeating what I said in that round table on 24th July, where everyone, including the self-appointed civil society's representatives, were also there. One is the Prime Minister's inclusion, and the other is our judiciary. I'll take up the judiciary first. It's no institutional bias. It's not because I have been judicial independence and this aspect and judicial review, they are basic features of the Constitution. Part of the basic structure, which is indestructible, which the Parliament also cannot by amendment of the Constitution remove. So you can't do anything which will have that impact. Then another internal evidence on this issue. The subordinate judiciary's control under Article 235 is vested in the High Court, which is the higher judiciary, not in the executive or anyone else. And therefore, you see, a subordinate judge cannot be subjected to any kind of control by anyone other than the High Court, that's the higher judiciary. If the subordinate judge in the constitutional scheme cannot be controlled by someone else outside the judiciary, how can a High Court or Supreme Court judge be not given at least that benefit? So Articles 50 and 235 alone, according to me, are sufficient to give that indication. But that does not mean that the judges are not accountable. And I am the last person who would say that. What is being talked of, the need for a federal law, 20 years back, my dissent in Viraswamy was on that ground. I said there is a felt need, make a law. And there is a provision in Article 124 which requires a law to be made by the Parliament to deal with this aspect. So I had said at that time, you see, the first P.K. Goswami Memorial Lecture in Guwahati I had given in 94. This was the theme. Latent dangers, I said, this is what has to be done. As Chief Justice of India in 97, those 3 resolutions which I had got passed, Mr. Kalab is fully aware, and now everyone is, because that's in the public domain. Now, they related to accountability. The Judicial Accountability Bill, which is in the offing, was initiated by a letter which I wrote to the Prime Minister on 7th April 2005, indicating all this. And before I left office on 1st December 97, with these resolutions I had written to the Prime Minister, I have given you the framework for the kind of legislation needed. These resolutions, though unanimous by Supreme Court, have only social sanction. In my time, I enforced them and did even appoint any judge who did not give in writing his commitment to abide by it, although it wasn't followed up. So I said it needs legal sanction to be enforceable. Now, that accountability of the High Court judges and Supreme Court judges is to be enforced by adequate provisions being made in the Judicial Accountability Bill. Lokpal is not the panacea for all ills. You see, you don't have it. And if you can't trust any of the existing institutions, who is that person whom you are going to get to become Lokpal? Is he going to descend from heaven? It's just not possible. And then if Lokpal goes wrong, where does the aggrieved person go? He has to go to the High Court and Supreme Court. So the Lokpal sits over the High Court and Supreme Court. And the High Court and Supreme Court sit over Lokpal. I don't think, at least to me, I have not been able to. Now, no one has tried to answer this. These are reasons which I am repeating here, all said in that round table, where all of them are present. And so, kindly bear this in mind. When people say, don't include it in Lokpal, none of us is saying that judges are not accountable. In a democracy, everyone, whoever he may be, is accountable, but the mechanism for enforcing accountability need not be the same at every level for everyone. coming to the Prime Minister, you have provision in our constitution for President's rule in a state. So Chief Minister's position is not the same. You see, you can have the President's rule, no instability in the country, no problem. The Constitution provides it. You have a Prime Minister included within Lokpal, howsoever efficient, etc., may be the Lokpal. The moment the inquiry commences, he becomes a lame-duck Prime Minister. There is no provision for a President's rule at the center. Not only nationally, internationally, you become unstable. Is that good for the country? It's not that he is not accountable, but for every aberration to be corrected, it is not a direct judicial remedy, political remedy. So long as it enjoys majority of the House of People, he will remain the Prime Minister. He would not be immune from general laws, but then he ceases to be Prime Minister. Supposing, take an extreme case, he commits murder. Well, or a Supreme Court judge or a High Court judge commits murder. Well, it's not that he is not accountable, he will be under, but he will lose office. And Prime Minister and Chief Justice of India also cannot be equated in this respect for a very obvious reason. If the Prime Minister goes, the Cabinet goes. If the Chief Justice of India goes, everyone else remains. There is no difficulty about that. So this argument also, and I said it when I was myself the Chief Justice of India, after disclosing it today, the Prime Minister then consulted me at that time. Then also there was a talk. I said, tomorrow, if I am made the Lokpal, and you ask me, I'll say keep the Prime Minister out. Because let the political process only correct that. So these are some of the things. It is not a matter to be taken lightly. Accountability, yes. But it is not one size fits everyone. See, people have different sizes, and therefore the remedies have to be different. I think these are all serious matters, and therefore my conclusion I would end by saying this is the true role of democracy, and that's this last word, and this is actually the last word. See, I've been talking for too long. Professor Jeffrey Jowell said, law is seen as institutionalized morality. So the moral component has to always be borne in mind. Well, I've tried to put it, that formula which I devised, and someone can improve it better do. Why are two different words, law and justice, used? We say administration of justice in accordance with law. Law is the instrument for doing justice, that is the aim. Mathematically put, and that's the only mathematics now I remember. See, law plus x is equal to, there has to be something added to law to equalize with justice. So law plus x, let us call it x, is equal to justice. The attempt should be to reduce the x component to 0 so that law plus x becoming 0 is equal to justice. What is that x? That is the component of morality. And therefore, the task of the judges, the judiciary aided by lawyers, is to help in making the courts read the letter of the law and interpret it in such a way so that it equates the letter of law with justice. And that is really the true role of the judiciary. And you see, to begin with, in the area not covered by statute law or the common law, see earlier, that is what was provided was where there is no specific provision of the statute law or common law, then how do you decide? Justice, equity and good conscience. These were the three words. Justice, equity and good conscience. Now that is that element which is needed to be read, and you call it the X component or whatever. And the role of judiciary is very significant, and it was aptly put by Addison, who said, to be perfectly just is the attribute of the divine. To be perfectly just is the attribute of the divine. But to be so, to the best of our ability, is the glory of man. I think that is what. So I'd like to end here. That is the true role of the judiciary. Thank you very much.
We now have the floor open for any interaction. Questions, if any, just raise your hands and then we can send the mic home.
Justice Verma, whilst I congratulate you for being a pioneer in judicial activism, I feel that you've been perhaps a bit unfair in your remarks that you made about the Lokpal activists. I suggest that when Justice Hegde was here last month, he gave us the example of a judge who had clearly committed an infraction. It was very clear to him, it was clear to the Chief Justice of India at the time. He named the Chief Justice, I don't know who it was, but he named the Chief Justice. And he said the Chief Justice refused to take action because he was a member of the same profession. I think, with respect, one needs to have an outside body. I'm from the National Health Service from England. I've lived abroad for 45 years of my life. And I draw a parallel here between what you said just now and what the doctors, the consultants in England say. So the consultants in England, for example, do not like an outside body reviewing their activities. But it has been found over the years, and I've been associated with them for a long time, that a certain amount of oversight from outside is useful. Now, I accept your point that a Lokpal on his own is as liable to misuse his position and liable to be as incompetent as someone else. But that is a question of fine-tuning the institution, fine-tuning the institution of the Lokpal by, if you like, having a committee rather than one person. But I would suggest to you, with respect, that to say that the judiciary should be outside the scope of review by outsiders is a bit, it smells of incest. Do you not think that an outside review would be helpful?
Now, my short answer to that is this. Well, it is not correct to think that those who have a different point of view are suggesting that there ought not to be an effective mechanism to enforce accountability of the higher judiciary, including the Chief Justice of India. I mean, I was saying that even when I held that office. It is the form of that mechanism, and that is to be considered not necessarily under the Lokpal bill to cover everyone, but the Judicial Accountability Bill, which is already in the pipeline. You make all those provisions which you think are necessary, make these suggestions and consider them in that. But since the Constitution itself treats the judiciary differently, the point is you can't merge it with the other categories to be covered by the same mechanism. Whatever mechanism, if you want to have, if you consider some outsider should be there, fine. Put him also there. But then that should be, there is a separate law because there is a separate provision for the judiciary, the higher judiciary. So you can't have one size fits all, that's what I said. Have it. And even an outsider you may have there. So it is, there is no, I mean, I would be the last person to suggest that you see they are not accountable or that, no, I didn't want to say that, but when you said about that instance, well, incidentally, I know more about the inside than my dear friend Santosh, who is also a lawyer before me.
आपने दो भारत की बात की। इस दो भारत का निर्माण हमने पिछले 63 सालों के आजादी के रूल के दरमियान किया। इस 63 साल के दरमियान यही हमारा महान बंधारण, यही हमारी ग्रेट सरकारें और ग्रेट जुडिशरी सिस्टम प्रेजेंट थी। तो क्या ऐसा नहीं कह सकते हैं कि इन तीनों ने मिलकर ही इस भयंकर भारत का हमने निर्माण किया है?
Every one of us. The entire set, not only all these organs of the state, every one of us, by letting it happen, has contributed to it. Because you see, why did we not raise our voice and stop this from being done? Every one of us, not only those who have been in office. You see, for example, I don't hold any office for many years, but I consider myself to be equally responsible, even without any office. That is the role of the civil society. That's the role of the civil society.
I'm very happy that you have come to Goa.
No lordship, I'm just
No, anyway. Yeah. Now this country has been going to dogs, and I want your lordship to bring back. To bring back the jury system which was prevalent in this country, so that you can save the country. And since you have been retired, I hope you will pursue this matter. Thank you.
Sir, as rightly mentioned by you, organs of the state are like our limbs. For a healthy state, all limbs have to perform well. The general perception is that except the judiciary, other limbs have one thing. That being the case, I have 3 questions to ask. One is that people who can afford are able to approach judiciary and get justice. But there is a large section of the society who are, injustice is being meted out to them day in and day out. They are not able to even afford, roti kapda and makan kind of thing. Who will give justice to them? Don't you think there is a need to put in some system or some kind of mechanism so that some justices, they are not able to even approach anybody because they don't have that affordability kind of thing. Who will give justice? Then if that being the large section, what kind of good governance we can expect? Question number 1. The second question is that justice delayed is justice denied. It's a famous saying. If that being the case, don't you think there is something need to be done to ensure that early justice is being delivered so that good governance can be achieved? Now the third question, I just take your own mention just now. You said that a corrupt judge will be there only when there is a corrupt lawyer. I'll take this little further. I just quote Ramakant Kalap election. When he lost elections, there was a general discussion, and they said that because he lost, because he is not corrupt, he is not fulfilling the wishes of the people, so he lost the elections. Number 2, I was recently discussing with one young legislator from Goa, and who is normally known as a non-corrupt. When I asked him that I am hearing, I have a close contact with him, I am hearing that there is some kind of corruption which people also talk about him. He said, see, I can't survive because people expect that I have to help them in terms of giving donations to some clubs, I have to do this, I have to do that. This is the kind of system which is there. That means that people are electing generally said that a non-corrupt persons because people have their self-interest to be done. That means people desire whatever they want. Under this kind of system where the limbs have gone sick, what do you think that the great role judiciary has to play? Do you think one judiciary can do a good governance having other limbs sick?
No, you see, just as one part of the body can't perform the entire function of the entire body. Similarly, no single organ of the state can do everything. The judiciary's main role, apart from what is obviously its role, is to also compel performance by those who are failing to perform. And that is what has given rise really to judicial activism. Laws delays, you are right. Simply reading speedy justice into Article 21 is not enough. And justice delayed is justice denied. But along with that there is another thing. Justice hurried is justice buried. So, I mean, you have to draw a balance. Well, not